feel ahead in the matter of key on the application of British Medical Association and the key on the application of Fire Brigades Union and Appellants and HM Treasury and Nugee.
This is short.
My lady, the reason I'm standing up, my learned friend is happy for me to do this. It is simply this: your ladyship should have a copy of Section 18 of the Public Service Pensions Act 2013 on the desk, loose.
Not so. No, I've just brought those.
There,
yes, I have. Yes, I have. I'm sorry. I've just covered it up.
Yesterday, my Lord Justice Nugee asked me if it was anticipated at the time of the Act that there would be transitional provisions. There is reference to them in the directions, and the reference is to Section 18(5) to 7, I think. But for completeness, these are those regulations. This is the provision anticipating scheme regulations for transitional provisions for people who are in the scheme immediately before the 1st of April 2012. And subsection 6 anticipates in particular transitional protection being given to someone who attained normal pension age on or before a specified date. So that's the provision in the Act. From the so.
Thank you very much. That makes it complete.
And subsection 7 anticipates the tapering.
Yes.
Provisions. Yes.
People who won't within 10 years of normal retirement, but within 15 or 14 or 15 years.
I think it was 3.5 years or something. It doesn't matter. When the regulations came in,
yes,
their effect was that some people could stay in the legacy schemes for the entirety of the rest of their service.
Yes.
Other people had a later taper date in 2015.
Yes.
Am I right in thinking that now, as a result of the McCloud judgment and the remedy and the new Act, everybody has left the legacy schemes as from April 22 and moved into new schemes? Or is
yes.
That is right.
That's right, across the board.
Yes. Thank you.
Ms. Morris.
I turn now to ground 2, and I'll deal at the end with section 31, which arises under both grounds. In outline, our case in relation to ground 2, the public sector equality duty, is that the judge failed correctly to apply the principles from the case law and thereby erred. First of all, he failed to apply the requirement that equality should be considered as a preliminary and with an open mind. The judge himself acknowledged that when the EIA was looked at, the door was only slightly ajar. Secondly, he wrongly placed reliance on the fact that the McCloud decision itself related to equalities in order to reduce what was required in relation to the remedy. Thirdly...
Sorry, could you repeat that, because I don't quite understand that.
So the judge wrongly placed reliance on the contextual factor, i.e. these questions arose as a result of the McCloud decision, which itself was concerned with equalities,
yes,
in order to downgrade that which was required in relation to deciding what to do by way of remedy.
Thank you.
Thirdly,
I'm so sorry, it's my fault. What do you mean when you say what was required by way of remedy?
What was required by way of the PSED in relation to the remedy.
Right, okay.
Thirdly, he wrongly placed reliance on material which was not placed before the minister when it is a personal duty to consider the PSED. And then lastly, he failed to apply the requirement that the exercise be carried out with rigour by rejecting the claim on the grounds that what was being sought was too precise, although in fact precision is what the Supreme Court has held in HOTAC approving bracking.
doesn't it all depend on the nature of the decision? Because there are some sorts of detriment which can be precisely appreciated and measured, and there are some which are less easy to measure precisely.
Milady, yes, although as I'll show the court in a moment, first of all, the case which failed on the grounds of a request for a high degree of precision. The precision which was included in that PSED was very much greater, and I'll also be able to show the court the PSED which was carried out in another part of the McCloud context, which itself, the precision was a great deal higher. So it's absolutely correct that with this ground, as in relation to consultation, it's sensitive to the
So how
fact.
does showing us other PSEDs help us to decide whether or not the judge's assessment of this, EIAs, how does that help us to decide whether the judge's assessment of this EIA was wrong or not?
Well, Milady, I'll show you it in a minute, but the reason we say it's material is because it shows what the government considered was necessary in order to fulfil the PSED in a closely related context.
I mean,
It also-
so what? They might have overdone it. I mean,
But-
how does it help?
It
It's a
al-
forensic point, isn't it?
It also shows, my lady, what was possible to be done when it's suggested by the respondent in this case, when they were a defendant, that it wasn't practical to be able to produce that degree of particularity. And so we say, certainly it's not the beginning and the end of our case, but it forms part of the contextual factors which we say are not irrelevant. So just briefly reviewing some of the facts, if I can remind you of the material we looked at from the decision-making process yesterday. You'll remember seeing the January 2019 submission giving a steer, and that was followed by the document saying that what was proposed was a tweak to the cost control mechanism. And then in April 2020, a recommendation that members bear the cost of the remedy. Then by 23rd of April 2020, a decision had been reached to include the McCloud remedy cost as a member cost. Now, at that stage, the only mention of equalities issues we get from the statement of Mr. Elks, which is in the supplementary bundle at tab 2, page 69. And at paragraph 130.
Oh, I'm so sorry.
And it's the second sentence. The readout note of a meeting notes that the Chief Secretary thought there was an intergenerational fairness aspect that needs consideration. So that is all we have in relation to equalities issues at that stage in the decision making. It doesn't engage with the consequences of those intergenerational issues in relation to protected characteristics such as, say, sex, race or disability, or the dimensions across the scheme. And so, for example, the fact that members of the firefighter scheme will have a different profile from members of the NHS scheme, for example, as those protected characteristics are engaged.
Does it matter?
Yes, it does.
I mean, the way Mr. Short addressed it, not quite this point, but a similar point to us, was if you focus on age discrimination, it's perfectly obvious that introducing anything which loads costs onto members of a scheme will impact younger members more than older members. And it's not difficult to suppose that in most public sector employments, younger cohorts tend to be more diverse. Do you need any more detail than that?
Well, My Lord, that's not what the authorities going up to the Supreme Court say, that you can rely on something being perfectly obvious. What is required, and I'll show the authorities, is for something to be addressed with rigour. It's an essential preliminary. There needs to be precision. So if I can show my Lord what is said, and of course it's also right to say that the only time that, as we understand it, the government say there was compliance with the public sector equality duty is at the very end of the process.
On the 1st of October, yes.
Yeah.
Yes. So,
Well, hang on, you said the only time there was compliance with the public sector duty. Do you mean that?
Or when there was purported compliance, that's what they rely
yes.
on.
So all these other preliminary stages, like the note we've just looked at paragraph 130, I don't think we actually have to read out the note of the meeting. But we've just got what Mr. Elk says.
We've filleted the bundles, as
Yes.
you imagine.
Chief Secretary, whoever the Chief Secretary then was, raises a question about intergenerational fairness. Now, you can't complain about that. That is a minister volunteering a point which is not included in a submission and saying, could you please look at this, because there might be a question. Now, the fact that she doesn't go on to say, she or he, whoever it was, doesn't go on to say, and you should not only consider intergenerational fairness, but younger cohorts might be more diverse, doesn't seem to me to add anything. The minister is raising a question of equalities in a very general way, asking her staff to go away and think about it. What do you have to complain about that?
As I see, am I right, Ms. Morris, the way the referring us to that was, this is the straw in the wind. This is all there seems to be at that stage. That maybe the Chief Secretary is saying, we need to think about this, but that's all.
Precisely.
I thought that was your point.
Precisely. And what we know happens next, as I showed you yesterday, is the July 2020 document, which says you made 2 decisions, so past tense. So when we have a document saying you made 2 decisions, what Mr. Justice Choudhury said was that just gives you the impression of finality, but we have an impression of finality where the only indication of consideration of equalities is this reference to intergenerational fairness, and we say that isn't what the PSED requires, and we can see that from the authorities. Now, the document that refers to the 2 decisions having been made, later on, and I showed you this yesterday as well, it says that their subsequent consideration does involve consideration at PSED, but we've never seen or been shown any PSED assessment in relation to that. And there's no other material to suggest that any work of the necessary quality has been done at that stage.
Necessary quality or any work?
Well, any work. We haven't seen any work apart from...
Okay, I was just wondering whether there is something else that is of a lesser standard.
Well, the way in which the respondent puts its case, as I understand it, is, well, we were thinking about it, but in terms of documentary material...
We've got nothing.
The only time we see a PSED is
at the end.
So obviously, the court will be familiar with the fact that often people produce one in draft as they go along, but we don't have that material in this case. Then we've got July 2020 and the ministerial statement, again, which I showed you yesterday, which says the McCloud remedy falls into the member cost category. And again, at this stage, we haven't got any documentary material of the nature that I've just discussed with my lady. But then we get...
just before you move on from that, I think you're referring to a Treasury submission 27th of July 2020?
The 16th of July.
16th of July?
It is the 27th. Oh, sorry, it must be a typing error.
Well, it doesn't have a date on it, but I think that's what
Yes,
you told us. And when you showed us to yesterday, that does refer to the PSED and a PSED assessment. and does say, I think this goes to the Chief Secretary to the Treasury, although it doesn't actually say, it does say on page 241, we saw this yesterday, newer members are likely to be generally younger. Younger members tend also to have other protected characteristics, so the transfer of costs could also have a disproportionate impact on them too. And you said yesterday, I think, that this PSED assessment, which is referred to, isn't the relevant one, and you hadn't seen it.
Yes.
And I'm not sure that I now understand that, because it seems to be addressing the very question which ought to have been addressed, isn't it?
My Lord, we've never seen a document.
Right.
There are two possibilities, and the one I advanced yesterday is the possibility that was the equality impact assessment which was carried out in relation to another matter.
What other matter? What other matter? Because I don't understand.
The type of solution in terms of whether it should be deferred benefit or not. So I'm going to show you that in a minute. But the other possibility is that what's said there is addressed to the issue with which we are concerned, but the fact remains, my Lord, that we've got no document. We've got nothing other than that statement at 241. And if it's being said that statement at 241 fulfills the PSED, we say that clearly isn't compliant with the legislation or the way in which the case law says the legislation should be interpreted and applied.
Well, as I understand it, it's not being said that this assessment complies with the legislation. It's not what is relied on as the PSED assessment. What's relied on is the one on the 5th of October, just before the directions are made. But reading this naturally, it suggests that back in July 2020, thought was already being given to equality matters, and that they are then kept under review throughout the period, culminating in the final assessment on the 5th of October. So it doesn't come out of a clear blue sky 2 days before the directions. Now I may have misunderstood it, but that's why I'm puzzled by you suggesting that this is dealing with something entirely different. Which,
Lord, as I indicated at the outset of the outline, what the case law tells us, I'm going to show you in a minute, is that the equalities issues are an essential preliminary. That's the phrase that regularly appears. So one of the questions we say in this case is looking at, for example, 241. Does that, can that satisfy a court that duty was considered as an essential preliminary and with an open mind? And we say, if what we have is that which I showed you from Mr. Elk's statement, and that which is contained on page 241, that does not meet the requirement, because if there is to be consideration with the right degree of rigour as an essential preliminary and with an open mind, that threshold has not been reached on the facts of this case.
yes, my question is a different one, which is not what the law requires, but what the facts are, which is this assessment referred to on 241, which is said to be something that is going to be kept under review, part of the process that leads to the final assessment on the 5th of October 2021, or is it something entirely different? That's a factual question. It's not a question of what the law requires. It's just a question of what happened. And it may be that you say, we don't know, which I think is what you did say yesterday. But reading it, it looks as if it is directed. It looks to me as if it is directed at this question. Who's going to bear the costs? Which cohort is going to bear the costs? There's a McCloud remedy, which is precisely the question that you say should have been considered. So I would like to understand whether the factual case is, your factual case is, there was no consideration at all until the last 2 days of this issue, or whether your factual case is, well, it did start to be considered back in July 2020, but we haven't seen it, and all we've seen is the final outcome.
Well, my lord, as you put it right at the outset of your most recent intervention, the difficulty for us is we don't know.
You don't know.
Because we haven't been provided with anything. In the ordinary course of events, if there is a draft EIA, then that would be provided. We haven't been provided one, and therefore it's left to us to speculate how best to understand it, and I've suggested two possibilities. But if it is either of those, we say if it can't be provided, or if the consideration is as much as we can derive from 241, neither of those is sufficient to fulfil the duty in this case.
Why do you say, sorry to take up time with this, but I do want to understand what your case is. Why do you say that what is referred to on 241 might be dealing, I understand you don't know because you haven't seen it, might be dealing with something else and not our issue, which is whether it was fair to put the costs on the members as a whole?
Because what we do know is that there was a very detailed EIA in relation to whether of the type of resolution in terms of the type of remedy. So I was going to show it to you just at the end of this section, or to show you the other way in which it was dealt with in relation to a related issue.
Thank you.
And before you do that, obviously, my Lord Justice Nugee has referred to the body of 241, but it's important, I think, to read 8, 9, and over the page at 242, 10 and 11 in order to look at context. And 11 says, we will continue to update this assessment throughout the process. And 9 and 10 have been talking about cohorts and some younger cohorts having other characteristics, etc. So that is the background at that stage. I only want to draw that to everybody's attention. I appreciate what you say.
But, my lady, if I can just remind the court of the point I made at the outset, that this document tells us about the PSED, having said at its outset that the decisions have been made. So what we've got is someone saying, you've made these decisions, now we're going to think about the PSED, and that, we say, is clearly wrong.
Yeah, and that's at 238.
Yes.
What's the decision that's being challenged in these proceedings?
My lady, you're absolutely right. It's the decision to make
Well, I was just
direction.
wanting to check.
But the difficulty, my lady, is this, that, and I will show you, that the duty is something which is an essential preliminary. One of the other words that's used is it's embedded in the process.
But this is, I mean, what does any of that mean?
Well, those are the words of the court, my lady. I can't do any better than that, I'm afraid. Both of those are language taken from the Supreme Court, and I'm doing my best with it in the circumstances.
So please do go on. You've referred us to 238 where it says the decisions are made. We've looked at 241 and 242, which make general references and suggest that an assessment will be kept under review. I'm sorry, I don't want to use imprecise language. Will be updated throughout the process. And then you were going to take us to?
Well, then, just to remind you, we have the written statement in July, which again says in terms that the that the McCloud remedy falls into the member cost category. And again, we've got no more than what we see in Mr. Allen's statement and at 241 at that stage. But what we then get is the ministerial submission, which finally refers to the PSE document, and we have that in the supplementary bundle at 26.
At page?
Tab 26, page 454.
Thank you.
And so this is headed amending directions. The issue is agreement to publish the amending directions. And then there's about halfway down the page, recommendation. Having considered the equalities impact assessment, you agree to publish the amending directions. Do you agree? So there is express reference to consideration of the EIA. But if you look at the way in which this is then explained over the page at 455, at the end of paragraph 3, the material decision again is in the past tense. It was also announced that the McCloud remedy would be included as a member cost when the 2016 valuations were completed.
Sorry, where is that?
The end of paragraph 3 on 455.
Thank you.
So it's not being suggested, we say in this document, that that decision is still up for grabs in the light of consideration of the EIA. And then if you have a look at paragraph 4, the last sentence, following your decision not to legislate for the McCloud remedy to be included as a member cost, there are no outstanding decisions to be made. So it's, we say, insofar as there's an invitation to consider the EIA, it's only in the light of the fact that the material decisions have been made. And then if you go on to page 457, paragraph 11, there's an acknowledgement there of resistance on the part of those affected, but the focus is on justification for the decision, not the adverse impact. So what you'd ordinarily expect to see if there's genuine consideration of the EIA is to confront head-on the negative impact and see whether that can be mitigated or addressed. But what you've got here is someone saying, well, you've already decided that the McCloud remedy should be a member cost, and this is the justification for doing it. There isn't any proper deliberation about how the various interests ought to be balanced. I
don't think paragraph 11 is dealing with equalities impact at all. It's dealing with the argument that has indeed been put forward by Mr. Short, that it's unfair for members to bear the costs of remedying the government's own wrong in discriminating. And paragraph 11 is saying that there is an answer to that. That's not an equalities impact issue at all.
Well, what I'm seeking to do, my lord, in drawing the attention to that, is the fact that the focus there is on justification rather than confronting the potential negative impact.
But the EIA is then dealt with in a separate section. You're going to refer to that.
Yes, but it's a similar tone here. There isn't. They refer to the PSED document, which I'm going to show you in a minute, and there's an acknowledgement that it will impact on value of benefits, and that there may be differential impacts by protected characteristics. But there isn't the analysis that we say is necessary, as between different cohorts. For example, you can, as I've indicated, imagine the differences between the Fire Brigades Union, which is largely comprised of white men, and the NHS, where there are going to be very many more women, black people, people with disabilities, and so on, where the impacts are likely to be very different.
Which I haven't quite understood that submission. Which of the two schemes do you say the impact is more noticeable?
Well, we say it's difficult to know because the work hasn't been done, but what we do know is that as cohorts of people, typically those in the Fire Brigades Union will be men, they'll be white, and of course they're very unlikely to have a disability, whereas
So what? So what is the consequence you draw from that? The impact on the Fire Brigades members is less significant or more significant?
Well, the the issue that we're seeking to raise, and indeed all the trade unions sought to raise, was the need to look at the likely difficulties. The difficulty for us, as only one of those trade unions, is that we don't have the data or the overview which the Treasury had and which we say they should have deployed to carry out this exercise.
Do you dispute what's said in 16A? That members who are not eligible for remedy are typically younger, are more likely to be female, and have other protected characteristics. Is that an accurate assessment of the global picture? I have your point, it should have been more detailed, but as a statement of the global picture, is there anything wrong with that?
It's very difficult for us to say because we don't have access to all that information. We are just one trade union, the doctors' trade union. We don't even have access to information in relation to nurses or physiotherapists or other health service workers. The difficulty for us is that the only body that was able to carry out an exercise, we say, with the necessary sensitivity to the different cohorts, was the government, and no one of us is able to undertake that work in order to answer those questions in a satisfactory way.
Thank you.
So basically you're saying 16A and B are hopelessly high level.
Well, I wouldn't necessarily insert the word hopelessly, but they're certainly not adequate, we say, to meet the duty. Then if we turn within the bundle to...
I'm sorry, what do you say, if anything, about 17 in the middle of that page? Because after having made the notes at A and B in 16, it's fair and proportionate.
Well, again, we say that's just a conclusion that they're not able to reach because, as I'll show you, there just isn't sufficient analysis to allow that conclusion to be reached with any confidence. And this takes us to the point about the degree of precision that is required, particularly when you've got diverse cohorts. So then if you turn then to the EIA that was produced, and we have that behind tab 8 at page 464. Now again, this document is prefaced with an analysis that McCloud remedy costs are member costs. So if you have a look at page 465, the second page, the second whole paragraph down, the costs that are assessed by the CCM are known as member costs.
Yes.
Well, what's wrong with that if that's the policy, the impact of which is being assessed?
But we say the problem with the way in which this is set out is it's predicated on the view that the McCloud remedy costs are member costs.
But that's a political... There's nothing in the legislation which tells you to divide costs into member costs. We saw this yesterday. Member costs and employer costs. It's a policy decision by government. It's not something that Parliament has looked at or dictated. It's government decided that the correct way to implement the recommendations in Lord Hutton's report was to divide the costs of schemes into broadly what benefits people are going to get, which are member costs, and how you have to pay for them, which are employer costs, financial and technical bits. Now that's a policy decision that was made before the legislation, as we were shown yesterday. And then when the McCloud costs came up, there was a submission to the Chief Secretary of the Treasury asking the Chief Secretary to make a decision whether they should be treated as member costs or not, with a recommendation that they should. And the decision was that they should. And that was a long time, I can't remember, 2019 I think, before this document. So why is it inaccurate by this stage to carry out the equalities impact assessment on the basis that the decision's already been made to treat these as member costs. The question is whether that has an unfair impact if you then go and put that in your direction.
That's precisely the difficulty, is that it's putting the cart before the horse. If, as my lord has postulated, a decision was made to treat these costs as member costs, that decision should not have been made without carrying out the EIA in full beforehand. What we've got is a decision being made that member costs, that McCloud costs are member costs, and then the cart being produced, as it were.
Well, the mere fact you've decided that they're correctly classified as member costs, I know you have a submission which you made yesterday that was an indirect, that was wrong. They shouldn't have been treated as member costs. They should have been regarded as employer costs. But given that the decision that they do more, they are more akin to member costs and employer costs, you still have to make a decision whether to put that into the secondary legislation directions so as to put those costs on the members through the cost control mechanism. That's the actual decision which was made on the 7th of October by publishing the directions. And at the moment, I don't see what's wrong with this assessment being written on the basis that these costs fall into that bucket. You still have to decide whether to follow that through into directions which will affect what people actually get.
Well, my lord, may I just follow through that chain of reasoning? So, as I understand what my lord is saying is that a decision was made as a matter of policy that the McCloud costs were member costs. But what was done at this stage in 2021 was a decision about whether or not to implement that policy in these directions. Is that how I should understand what my lord is saying?
Well, that's what I had understood. The facts, I mean, you always have to go back to what the facts are, but that's what I understood the facts to be. I think it was back in April 2020, the Chief Secretary to the Treasury was given us a submission saying, we think that McCloud costs are member costs rather than employer costs. And as you showed us, the Chief Secretary made a decision to that effect.
Well,
That is not a decision that they will be included in the CCM in amending directions, because that decision's not made until October 21, ultimately, even though, as the judge found, decision in principle to be made earlier, but it's still something where the door is ajar a little bit.
Well, my lord, we say that the law is not that the PSED arises solely at the how should I implement my policy decision stage. That is wrong, and I would.
Okay.
That we say if what it's being suggested is that you can make a policy decision with negligible consideration of the PSED, certainly not without an EIA, but you can then produce your EIA at the implementation stage, that is wrong.
Okay. Thank you.
Does that come from the language of section 149, or were you going to show some authority to assess that?
Well, there is plentiful authority, my lady, and I'm going to take it to you when I've finished reviewing the factual material, if I may.
And presumably you will share some link between in the authorities in relation to open mind and the time at which one must have the open mind.
Precisely, my lady. You're meant to have an open mind throughout, and we're going to say that if your mind is only slightly open when you look at the EIA, and slightly is the word used by the judge, although in relation to a door and not a mind, but we say that it maps across very neatly, then you are not, a slightly open mind is not an open mind. Then if you, staying with the EIA document, which we have behind tab 28, and we just looked at page 465, You looked yesterday with Mr. Short at the material on page 466 under the heading remedy status. And so there is the recognition, we say at, I don't want to insert my lady's word hopelessly, but at a inadequately high level of the difficulties. But we say there that you get that rather superficial recognition, and then insofar as it descends into particulars, you'll see that there is a formula trotted out under each heading with the identical language being used. So there's a heading age on 467 and 2 bullet points, and then another heading sex on page 468, where the first 2 bullet points are almost identical. And so we say there's a sort of formulaic response, focusing immediately on justification rather than on adverse impact.
Sorry, which is the bit that focuses on justification?
The first bullet point. So it says, well, this is inherent.
But that's sorry. Is that not dealing with the impact? Saying, because of the way the cost control mechanism is designed, there will be an intergenerational impact. That's not a justification for it. It's just explaining what the impact is, isn't it?
Lord, we'd say if you start with a justificatory statement, i.e. this is an inherent problem, particularly if you connect it with the way in which it's addressed ultimately, which is this is something that has to be weighed against the cost to the government, then there isn't any proper recognition of the risks so that there can be weighing up. What there is a focus on the most powerful justifications rather than analysis of that which is required.
So what analysis is required?
Well, lady, what I was planning to do was under the last heading, when I turn to the detail of the argument, is to show you that which was undertaken in the other case, but I could do that now if it's convenient. If you turn
Well,
within.
I don't want to take you out of your course.
Well, I wonder whether it's convenient since the question arises. If you stay within this bundle and go back to tab 15.
Page?
326. So this is the EIA that was prepared, dealing with whether there should be immediate choice or deferred choice. And just to show you the work that was done in relation to this issue, if you, first of all, at page 335, there's a heading, Equality Impact Overview. And then if you turn over onto page 337, at the bottom of the page, 2.18, there's a heading Other Protected Characteristics. What this document does is analyse by way of percentage the numbers of those impacted. And you can see that at 2.18 to 2.20. And then if you go on to 2.60, you've got a similar analysis. So I'm not going to ask you to wade through the whole thing, but what we're saying is that this is a qualitatively different document, and it shows what can be done, and it shows what the government considered was necessary to be done in relation to a closely parallel issue. Now, obviously, that's not the beginning and the end of our case, but we say it forms part of the context. And certainly if it said, well, we couldn't do any more, or no more was necessary, we say you could do more because you were able to do it in relation to this other circumstance.
Are you able to help me please with what the date of this document is?
I beg your
What's the date of this document?
2020, my lady.
Well, I can see that, but do you know when it was?
Lady, it's published in July 2020 alongside the consultation on the McCloud remedy. I actually find precise date figures. Probably in the chronology.
All right.
And then if you go back to the EIA that we have in relation to our issue, and then if I could just point out that, for example, the last two limbs of the duty are addressed at the bottom of 469 in a way which we say merits the description cursory.
What's missing?
Well, the level of precise analysis which is said to be required by the case law. Now, the next document I need to mention, but I'm just going to mention it and then move on to the law because of the way in which time is passing, is that another document was produced but was not given to the minister. So we say it falls out of consideration, and it's that document which you have behind tab 30 in the supplementary bundle, page 489. It's the actuarial analysis. But that wasn't before the minister. If I need to come back to it and reply, but I'm keen to get onto the law, given the time restraints. So turning to the law, if I can invite you to take up the core authorities bundle behind tab 6. And if I take things quickly, I do apologise, but I'm very keen Mr. Gifford should have all his time. It's a decision of the Court of Appeal with Sir Terence Etherton as Master of the Rolls, David Troy-Sharp as President, and Lord Justice Singh. There's a heading in relation to the public sector equality duty at paragraph 163. There's a review of the authorities, and then if you turn to page 201, paragraph 174, the Divisional Court doesn't refer to authority because the relevant legal principles were not in dispute. And then just I draw your attention to this, that the principles were set out by Lord Justice McComb in Bracking, and then it's well known as frequently cited with approval since, including in HOTAC. So these principles derive from that which was said by the Supreme Court in HOTAC.
Yeah, I've just been looking at HOTAC, and what the Supreme Court said was that none of the propositions in Bracking was in dispute in HOTAC, and if you read Bracking, none of the propositions was in dispute in Bracking either. So I think that's an important point to bear in mind.
Certainly, my lady. Well, perhaps we can explore what we do have in the case law and see whether there is a reason for it to be placed under attack. So for this, for our case, we invite the court's attention to paragraph 175. And just below H, it says, for present purposes, we would emphasise the following principles. The duty must be fulfilled before and at the time when a particular policy is being considered. And I would say that's the answer to my Lord Justice Nugee's point put to me a few moments ago. The duty must be exercised in substance, with rigour, and with an open mind. That's one of the many institutions of the word open. It's not a question of ticking boxes. The duty is non-delegable. The duty is continuing, perhaps another response to my Lord or Justice Nugee. If the relevant material isn't available, there's a duty to acquire it, and this will frequently mean that some further consultation with appropriate groups is required. And then, provided the court is satisfied, there's been a rigorous consideration of the duty. So we would be saying that what a court has to do is ask itself about the rigour and whether there has been a proper appreciation of the impact on all the equality objectives. And these are the other features of the duty which we say were given cursory consideration, desirability of promoting them, and so on. It also emphasises that it is, at 176, a duty of process, but that does not diminish its importance. And the reasons are that good processes are more likely to lead to better informed and therefore better decisions. Now, just to flesh some of that out.
Sorry, just to go back to the boring point I made a moment ago, were any of the relevant legal principles in dispute in fringes?
My lady, no. But what I would say is that these principles take force from the fact that they have been reiterated by the Court of Appeal and Supreme Court on a significant number of occasions. So, can I show the courts this phrase, essential preliminary, which we say is material to the facts of this case. One instance of it is in the bundle of authorities at tab 29, the case of Adiatu.
So we've gone away from court into Maine.
Yes, into Maine. So Adiatu starts at 849.
I'm sorry, it was divider.
Oh, 29.
Thank you. I'm sorry.
I do apologise.
No. Yes.
So this is a decision of the Divisional Court constituting Lord Justice Being and Mr. Justice Kavanagh, and I'd invite your attention to page 893.
Could you just help us by telling us what the issue in this case was, please?
Certainly, this is the Uber case, the Uber driver's case. Milady, I apologise if I'm not setting out all these cases in full, but I'm also keenly aware of the time pressure that's on me, and I'm trying to deal with things as crisply as I can. So in this case, it's 893 I'd ask you to look at. Paragraph 203, the importance of full compliance with the PACD as an essential preliminary to public decision making has been emphasised many times by the courts. Now, I accept, my lady, that it may be that that's not been disputed, but the fact that it's been emphasised rather than waved through, I would say, is something for this court's consideration. I wonder whether you would now...
Sorry, it's my fault. Which paragraph are you referring to? Sorry, I've got it. 203. Thank you very much.
So if the courts consider it appropriate to emphasise it, we would say it's not a mere nodding at the proposition. Then if I can ask you please to look within the other bundle behind tab 16 at the case of... Oh, sorry, tab 8.
Before we do that, it goes on 205. Due regard means what is appropriate in all the circumstances.
Absolutely, we absolutely agree that it relates to the facts of the case, and there's plentiful authority in relation to that. I mean, it's a necessary feature of both consultation and duty challenges that what's important is to focus on the nature of the decision and its impact. And we say here there was a decision of monumental significance to thousands of people, and that's why it required such careful rigour.
Are you taking us to Divider 8?
Yes, Divider 8, the case of Williams. It's a decision of Mr. Justice Wilkie. And again, there is an attempt to set out and enumerate principles. And it starts at page 237, paragraph 16.
Paragraph 16.
Yeah. Now, some of these are a repetition of ones to which I've already drawn your attention, but I'd ask you to look in particular, and just to make life easier, at all of them at this stage, because I'm going to come back to some of them, but just to draw your attention to the bottom of 238.9. A test of substance. Duty must be performed with rigour and with an open mind and is non-delegable. Doubly important for officers not simply to tell members what they want to hear, but be rigorous in inquiring and reporting. And then over the page 10, it requires advanced consideration before making any policy decisions that may be affected by such an issue. And then little Roman 11, due regard must be an essential preliminary, not a rearguard action following a concluded decision. And then 12, consideration of duties must be an integral part of the policy, not justification for its adoption. And 13, kept in mind throughout, it should be embedded. And so that's the source of the language that I've been using over the course of the morning. Now, perhaps to take things more quickly, my lady's indicated that she's looked at OTAC, and perhaps I can just give you the references. It's in the main bundle behind tab 12. If you have a look at page 347, paragraph 75, that is where it's Lord Neuberger endorses what's said in Bracking about substance, rigour and open mind. The other place where we have endorsement of what is said in Bracking is in the West Berkshire case, which we have in the same bundle behind tab 16. That's a decision of the Court of Appeal, Lord Justice's Laws and Treacy. And if you have a look, please, at paragraph 72, I wonder if we can just pause here because it deals with this issue of precision. And so what the Court of Appeal in the West Berkshire case does is cite what is said by Lord Justice McComb in Bracking. The concept of due regard requires the court to ensure...
Sorry, which paragraph are we?
Paragraph 72, page 440. The concept of due regard requires the court to ensure that there has been a proper and conscientious focus on the statutory criteria. That's done, the court can't interfere. So, in short, the decision maker must be clear precisely what the equality implications are when he puts them in the balance. And he must recognise the desirability of achieving them. But ultimately, it's for him to decide. Now, West Berkshire was relied upon by the respondent and the judge to say, oh, well, it shouldn't be mathematical or forensic precision. But in the light of that, it's perhaps worth looking at the facts of this case. And so if you stay with the West Berkshire judgment and turn to page 442, paragraph 80, and I just invite you to read the level of particularity that was provided in the equality impact assessment in that case, Now, when that was criticised by the claimants in that case, the court said, you're going too far. Paragraph 83, it's not a precise mathematical exercise. But we say that's distinguishable from our case because what the government achieved by way of the EIA in our case was something very much less than the level of mathematical precision, for want of a better expression, that was treated as acceptable in the West Berkshire case. So the question, I'm afraid, again is how do we read the word precise? Plainly, the Supreme Court has told us that there needs to be precision. What Mr. Justice Choudhury in our case said is you're asking for too much precision. And we say, no, that's not right. The government didn't reach the threshold of precision which was necessary given the character of the decision in this case. And then finally, in relation to the propositions of law, what the duty requires is exploration through the making of inquiries about what might not yet be understood about the potential impact. And then just to remind you what was said in Bridges, it's that kind of inquiry which produces a better decision. And then to remind you what I showed you from Williams and then again in Bracken. Now, we fully accept that what is required is always going to be fact dependent, but just to give you another example of a case which is relied upon against us, and it's a decision of my Lady Justice Laing, a case of Shake, which you have at tab 35. One of the reasons why, and I want to show you, but one of the key reasons why there didn't need to be more done in that case is because the decision that was being taken was experimental. It wasn't in Shake, it was an experimental decision taken in order to enable the gathering of information. Now, we would say that that is absolutely at the other end of the spectrum of the decision which was being taken in this case. It might be reasonable to rely on the analysis of the court in the Shake case if what was being said here is, oh, we're going to try doing it this way and see if it's too onerous or too unfair. But what you've got here is a categorical and final decision, not an experimental one. And that's why what was done in relation to the duty was not sufficient. Just to say perhaps the most convenient place to look at it is paragraph 56. But I'm not going to weary you with it too, because it's simply a point of distinction. But it's a radically different type of decision than the one in this case.
Can I go back to something you said a moment ago? You said the need for precision was something that the Supreme Court had endorsed, and I wasn't sure what you were referring to.
Oh, it's I showed you it in tab 12.
HOTAG.
I beg your pardon?
HOTAG?
Yes.
But the bit you showed us was Lord Newberger saying it needed to be rigorous and with an open mind. Did he endorse the requirement for precision?
Yeah, precisely. The phrase is precisely what the equality impacts are. So I think it was 16. I'm sorry.
16. I don't think we saw that, but thank you.
It's the quotation in the West Berkshire case. West Berkshire case is in tab 16, and it's
paragraph 72. Referred us to.
I think so. Let me just go back.
Clear precisely what the equality implications are. That's a quotation from Lord Justice McCloud in Bracken.
Yes, I'm sorry, I've been going at a bit of a canter because I'm aware that I've only got a little bit of time left. No, so that is a quotation from Bracken, and we know that Bracken is approved in HOTAG. So this statement from Bracken, we say, is endorsed by the Supreme Court.
I see. Thank you.
circumstances where none of it was in dispute, see the last sentence of paragraph 73 of OTAC.
Yes, but we would say, naturally, the question of what degree of precision is required is fact sensitive. But we say, in this case, given the magnitude of the individual impact and where those individual impacts will be significantly different, and where those differences are likely to arise from protected characteristics, then that requires more to be done than what was done in this case. And certainly, given what's said in the authorities about the need for that work to be done before a policy decision is made, then it's very much the case, whatever was in the ultimate EIA, that work certainly wasn't done before the policy decision was made.
Do we have to be careful, though, about the use of the phrase policy decision? Because in some cases, what may be at issue in the Section 149 challenge is a policy decision, and in other cases it might not be. But in this case, the decision that's challenged is the decision to make the directions. So isn't that the decision that has to be focused on?
But as I understand it, the decision-making process was characterised by my Lord Justice Nugee as a policy decision followed by an implementation decision, and it was being asked whether it was in that case perfectly proper for there to be EIA at the implementation decision stage. The lady, I'm drawing the court's particular attention to that in order to be sensitive to my Lord's questions.
I see. All right.
You referred to the magnitude of a decision, and both you and Mr. Short yesterday referred to the decision to include the McCloud remedy costs as making the members pay for the costs. I just wonder if that's a bit of a shorthand, and that's not entirely accurate. I'm sorry, I should have raised this yesterday, but what actually happened was that the 2016 preliminary provisional valuations indicated that floor breaches were likely to occur in at least many of the schemes. And that would have led, unless anything was done about it, to increases in accrual rates or reductions in contributions for the members. And Mr. Short gave us some examples of the impact of his particular members. That was because the valuations had shown a past service surplus because there had been less salary growth and less improvements in longevity than had been anticipated at the 2012 valuations, the preliminary valuations. So it throws up a past service surplus. That as I understand the evidence, is the main driver of the floor breaches. What the effect of including the McCloud remedy costs in the CCM is not actually to make any member worse off than they were before the valuation, in the sense that their benefits aren't reduced, their contributions aren't increased. It's that they miss out on the improvements they would otherwise have got as a result of the floor breaches. That's right, isn't it?
My Lord, I'm hesitant to argue, since I think that some of that is my learned friend Mr. Short.
Well, I think it's really for Mr. Giffen. But I thought I'd raise it now because you've referred to the monumental impact, and I just want to be clear as to the facts of what the impact is. And I think the impact is not that any of your members pay more or get less from the scheme, but that they don't get the improvements, either by way of benefit improvements or contribution reductions, that they would otherwise have got under the cost control mechanism. Is that your understanding?
My Lord, no. And
No.
And I don't want to take up my time.
Right, okay.
Well,
Well,
I will ask
Mr. Giffen to explain that in due course, but that is how I had understood what in fact happened, which is that putting the McCloud remedy costs into the cost control mechanism wipes out the floor breaches, and therefore nobody gets the improvements they would otherwise have got, but it doesn't actually make anybody worse off than they were. And so one way of characterising what's happened is the government's used the past service surplus to pay for McCloud rather than using it to improve people's pensions.
So, my lord, two things. One, I don't think that's right. Two, I'm going to leave it to Mr. Short to deal with it from our side. And three, we of course are relying on the way in which the government itself characterised its decision, and it keeps characterising it, as I've shown you in the documents, as saying we are going to treat McCloud remedy costs as member costs.
Yes, but that doesn't mean the members pay for it. It means they get fed into the mechanism to see whether there are floor breaches or ceiling breaches. That's the only purpose of the mechanism. It doesn't actually change anybody's contributions or benefits unless there's a breach. And what happens by including the costs is the floor breaches disappear. There are ceiling breaches in some of the schemes, I think in particular in the firefighter schemes. But the ceiling breaches are also waived so that nobody is worse off. By including the McCloud remedy costs, nobody's worse off than they were before. They're worse off than they would have been if the McCloud remedy costs hadn't been included. Anyway,
it certainly transpired that some people were worse off because then various breaches were waived in relation to some schemes.
I don't understand why that makes them worse off.
Well,
anyway, you've said you don't want to answer it, and I will.
I'm keenly aware
Yes.
that I have had my hour and a quarter,
Yes.
and I need to say something about the judgment. I need to say something about Section 31.
And for the same reason I'm reluctant to intervene, but my Lord's understanding is precisely mine. I hadn't appreciated there was any dispute about any of that, and if there is a dispute, I don't mind whether I hear it from Mr. Short and then from Ms. Morris. I quite like to know what the dispute is before I make my submissions.
Mr. Given, I was going to say, in order to break this particular logjam, that's quite clearly something that we need to pursue, but probably not with Ms. Morris, and that she should complete her submissions as soon as she can, and that I would like personally a thumbnail from Mr. Short about what he says is the effect, because I understand it in the same way as my Lord Justice Nugee, that ceiling breaches were waived, but it was a case of losing the opportunity for the benefit or might gain from floor breaches, if you can call it breaches, and that was it. But I don't think that impinges on what you were saying, Ms. Morris, which was actually this is all jolly important. I think that was the level at which you were pitching it, probably, rather than in pension terms.
Yes, certainly it had a significant impact. I don't think, and so if we compare it with, I don't know, a scheme about road use in a London borough, for example, we would say that this is, probably of a greater magnitude in terms of the numbers of people affected and so forth.
So please do proceed with your further points as soon as you can.
Thank you. Can I just invite you then to look at the judgment, which is in the core bundle behind tab 13. It starts at page 161. The relevant bits I just draw your attention to. The consideration of our submission starts at page 254, paragraph 222. But in particular, if I could show you paragraph 228.
Which is page
257.
Thank you. I'm so sorry.
No. I'm.
Thank you.
So paragraph 228 says there was PSED analysis that was provided to the minister before the final decision to make the directions. So the minister could, notwithstanding the strong preference expressed hitherto for including the MRC as a member cost, have changed his mind in the light of the analysis and disagreed with the recommendation. The door to a different outcome may well have been only very slightly ajar, but it was not completely shut. Well, pausing there, we can ask ourselves whether what we've seen in the documents was simply a strong preference, and if it's right that the way in which the judge understood the facts was that there was a possibility of a mind change, but the door was only slightly ajar, but not completely shut. I would say that something that is not completely shut is not open in the necessary sense, my lady. It's open, but not very far open. And if that requirement for an open mind is read together with all the other material in the authorities about the enduring nature of the obligation, we say it wasn't fulfilled. Then if you look back, please, to paragraph 226, what the judge says there is, it's apparent from the overall chronology that the PSED analysis, i.e. EIA, was not the first occasion on which the potential equalities impacts were considered. The context in which the issue had arisen, i.e. following court rulings that transition provision was discriminatory, meant that there was an acute awareness of qualities issues from the outset. Now, the fact that the McCloud remedy arose from a discrimination claim is not something, we say, which serves to dilute the consideration of equalities which was necessary at that stage in the process. Now, if that...
Is it irrelevant?
It's part of the picture, but it's not something, we say, which dilutes what was required, given the difference between what was being argued in McCloud and what needed to be considered at this stage. And indeed, in one sense, I suppose one might say it intensified what was required rather than reduced it, because what the government was having to do was consider how to remedy a discriminatory wrong. Now, if you're going to consider how to remedy a discriminatory wrong, you might think that would heighten your concerns about not doing something even more discriminatory or discriminatory in another way. You might say there ought to have been a greater sensitivity rather than a lesser one, and we say that the court therefore got that issue wrong. Insofar as the word we have in 227 was that there was awareness, the judge uses that word, he appears to rely on material in the paragraph just above at the top of 257, which was not before the minister. And we say that for example, as I've argued argued before you this morning, is that, for example, the material at page 214, while it might indicate an awareness doesn't reach the threshold of what's required by the duty as interpreted for us by the court. And it's also perhaps worth noting at paragraph 226 that the quotation there in relation to the Pensions Board paper acknowledges in the centre of it that further detailed work is required. But on the material which is before the court in this case, it appears that further detailed work was not done until the end of the process, despite an acknowledgement there by caseworkers that it was necessary. Now, the third point relates to the matter that I've just touched upon, which is reliance on material which was not before the minister. And I've shown you the authorities which say that it's a personal duty. And then finally, this question of precision. Now, I've shown you the material in the West Berkshire case. Now, and then just to show you what the judge said on this issue, that's at page 261, 240. The way in which the judge characterises our case, we say, is unfair. He says that our complaint is that the analysis was not based on a precise understanding of the extent of the impact, However, as stated in West Berkshire, a precise mathematical analysis of the effect of measure on different groups is not always necessary. The analysis here didn't seek to suggest that financial impact was trivial or insubstantial. The language of intergenerational unfairness, I showed you that, resulting from the different levels of benefit, implies an acceptance that these differences are substantial. It's not apparent knowing why knowing the precise levels of loss would be relevant, or how such knowledge could have influenced his decision. Now, we say that that analysis is wrong. First of all, as a matter of law, the degree of precision doesn't have to be mathematical, but asking for something to be precise is actually consistent with what the Supreme Court says approving bracking. So we were entitled to ask for a degree of precision, and we shouldn't have been castigated for it. And we say that, for the reasons that I explained, the issues in this case, in terms of their magnitude and in terms of their differential impact, did require more. And to pick up my lady's point, perhaps, given that what was being done was an effort to remedy something that was already discriminatory, this was a case where there ought to be heightened rather than lesser sensitivity to the impact of those matters. Now, we're often criticised, indeed, the issue has emerged this morning, that perhaps we're not saying enough ourselves about the differences between different schemes. And of course, we are not in the position to do it. And that's, of course, why the duty is put on the government to do this work. And we know that they're able to do the work because I showed you the other equality impact assessment that was done in parallel. Then can I just turn, please, to the Section 31 issues?
Can I just ask one final question, please? Is your submission that the decision which the judge made in relation to Section 149 was a decision that was not reasonably able to him on the evidence?
Yes.
Right.
And we say he got it wrong for the following legal reasons that I've articulated.
Section 31.
Thank you. You have Section 31 in the legislation bundle behind tab 1. And it's page 1. I don't know how it's page 1. And the relevant provision to look at is subparagraph 2a. And the question is whether it appears to the court to be highly likely that the outcome for the applicant would not have been substantially different if the conduct complained of had not occurred. And in terms of explicating that duty, you have Carver Yen in the core bundle of authorities behind tab 8. And that's a decision a challenge to a decision made by a local council in relation to a particular commercial property. So the proposition...
So this decision isn't binding on us, it's a decision...
No, but what we do say, and as I understand it, it's not disputed by Mr. Giffin, is that this is a helpful articulation of the principles, and therefore I rely on it at this stage in the proceedings, having already run by 10 minutes. So paragraph 52, critically we say, for the purposes of this appeal, the burden of proof is on the defendant. And then secondly, the highly likely standard of proof is a high one. Thirdly, highly likely expresses a standard somewhere between civil standard and criminal standard. Unfortunately for Mr. Justice Choudhury knew at 6, the test is not always easy to apply, and your task is an unenviable one. And then importantly, we say at 10 at the bottom of page 275, right at the bottom of the page, the court should approach with a degree of scepticism self-interested speculations by an official of the public authority which is found to have acted unlawfully about how things might have worked out if no unlawfulness occurred. And then anything that you do decide needs to be based on evidence. And then just to put a little bit more colour, if you turn within the main bundle of authorities to a decision of Lord Justice Sales at tab 19, it's the first bundle for me, page 479.
Tell me again, main case, main authorities bundle,
Tab
tab
19, page 479, and within the judgment, page 504. So a not dissimilar case to this one in that it was concerned with consultation, and the key question was what would have happened had there been consultation. And so at paragraph, so page 504, paragraph 89, a recognition of the high threshold. And then at paragraph 90, 90 and 91, similar type of evidence as in this case, i.e. witness statement on behalf of the defendant, but an exercise in speculation about how things might have worked out if no unlawfulness occurred. And then between F and G, self-interested speculations of this kind by official public authorities we found to act unlawfully should be approached with a degree of scepticism. And then between G and H, the Minister has not provided the Court with a full account of the ebb and flow of debate in the discussions, nor with the minutes of those discussions, to enable the Court to make a critical evaluation of the assertions made by Mr. Jinks about the counterfactual position. Nor has the Minister provided any detailed information about any discussions with HM Treasury relevant to the parameters under which he was working, or about his own internal calculations regarding the level of flexibility available to him in the negotiations. And then he goes on at 92 and says he's not impressed there by the defendant's criticism of the lack of evidence from the claimant. So again, we say that's a similar situation. It's we're being criticised, you'll see in the judgment, for not explaining what could or should have been done. But of course, what Lord Justice Sales says in the PCSU case is that's the wrong approach. And then if you turn over, please, to paragraph 98, that case, there was a negotiation with many moving parts in terms of different participants with varying interests and objectives, and with an uncertain and to some degree flexible possibility of financial accommodations between their interests. And I'd invite you to read the rest. So the points that we take from these authorities are as follows: that it's wrong to place the burden on the claimant, as we then were, to prove that something else could be done. Rather, the burden is on the defendant to a very high standard to prove that nothing else could be done. And in discharging that burden, the court should exercise a degree of scepticism about self-serving things said, particularly where, and I'd say that bears comparison with this case, we don't have all the material which shows the ebb and flow of debate. And so, for example, the PSED document. So that's the approach I say we should take. If you have a look then, please, at the judgment, which is back to the core bundle, tab 13, page 161, paragraph 218. So at the bottom of that paragraph, what the judgment says is the claimants have not suggested any alternative option other than the binary one of treating the McCloud remedy cost as a member or employer cost that could realistically have caused Treasury to deviate from the preferred option. That is the wrong way to look at the evidence. It's directly contrary to the way in which the judge should have approached the issue. And then, again, if you have a look at paragraph 247, he does the same thing in relation to the PSPA issue. Same language, in fact. Page 264, paragraph 247, 2/3 of the way down, there has been no credible submission as to how that would have made any difference. But the simple point is that that is not the way in which the statutory obligation works. And then,
Might it depend on the nature of the decision which is being made?
Milady, the statutory duty is imposed on the defendant and to a high standard. In my submission, if the reason for accepting a defendant's reliance on Section 31 is that the claimant has not advanced a positive case, that is an error of law.
Okay.
And then looking at it in a more granular way, I'll remind you of the evidence of Mr. Elks, which we say, without wanting to be unkind, does bear comparison with the descriptors that were given of Mr. Jinks' evidence by Lord Justice Sales. And in any event, in this case, there wasn't a binary issue because for the reasons which I've already touched upon this morning, we know that in some of the schemes, what came to pass ultimately is that there were breach waivers. So we know that there was flexibility within the scheme. But again, we say the burden wasn't on us to articulate what that flexibility might have been. The burden was on the defendant to satisfy the court. And it couldn't satisfy the court simply by saying, well, you haven't said what else we could do. Because again, of course, we're simply not in the position to articulate our case in that way. Now,
you refer to breach waivers. Could you just very shortly explain what you mean by that?
In relation to some of the schemes, I can give you chapter and verse in reply. We know that there were subsequently breach waivers. So in fact, the consequences of the inclusion of the McCloud remedy
Was eliminated, was
in some cases
neutralised
yes.
in some respects.
Is that right? My understanding of what happened was that the inclusion of the McCloud costs in all cases, I think, meant there were no longer any floor breaches. In some cases, it meant there were ceiling breaches. And if nothing had been done, that would have adversely impacted members in terms of either higher contributions or lower accrual of benefits. But the ceiling breaches were all waived where they happened. So that doesn't change. It's not different for different schemes. It's just that members they don't get the benefit of the floor breaches, but they're not asked to suffer the consequences of a ceiling breach either. I'm not sure how that affects. I'm not sure why you say that means it's not a binary answer. That was the binary answer. That was what was done. And the only other thing that could have been done was to require the ceiling breaches to be maintained and make your members worse off. And I don't understand how that helps you. Have I misunderstood the point?
Perhaps, I'm sorry to interrupt.
Yes,
perhaps, Ms. Morris, you will make that good in a very short, one-sided piece of paper which explains, and hand that up when you make it good in reply.
Absolutely, my lady. I'm very happy to deal with it in that way. So then can I just deal with the other argument that was advanced by the judge in relation to consultation under Section 31. He said the only real difference would have been, if there had been a consultation, it might have been an agenda item, or there would have been there was otherwise no real difference. But we say, when one recalls that the gunning criteria required conscientious consideration, And if one compares that with the material I showed you in Mr. Elk's statement, where I think a lady summarised it by saying, well, you would say that, wouldn't you, and it's no difference. That is not conscientious consideration. We say if the government had understood it was under an obligation to consult, it would have done very more, and I'm not going to say anything else.
Thank you very much indeed. Before we go on, and although we're getting hopelessly late and it's mostly our fault, Mr. Short, could you just give us a thumbnail before Mr. Giffen starts his submissions?
Yeah, my lady, yes. The benefits earned by members did not reduce chronologically. They were not lower than they had been in the past. The benefits earned by members, however, were substantially lower than they would have been. Or alternatively, their contributions were higher. But
Because of the flaw.
because there would have been
An improvement.
There would have been an improvement either to their contributions or to their accrual rates.
And in default of agreement, it would have been the accrual rates would have increased.
Yes.
And you gave us some figures which show the change would have been
Substantial.
quite significant.
Indeed. So we say that is not simply losing an aspiration, that's something they would have been entitled to.
Under the legislation, that's what they would have got had the 2016 valuations been allowed to complete without the McCloud
remedy. So whether that involves the members bearing the cost of the McCloud remedy, I accept that is a characterisation, but it is exactly the characterisation adopted by the government when it made the decision. There were submissions, pages 233, where we recommend the members bear the costs of McCloud, and 241 to the same effect, because if those improvements, expected improvements to benefits, had not been negated, the government would have paid for those improvements and it would have paid for McCloud. As it was, didn't pay for the improvements and they were more or less set off against McCloud, although there was some government cost from the waiving the ceiling breaches.
But you're not suggesting there is any other shadow effect of the McCloud costs. That's it.
No, although we say there is a very straight line.
Okay, thank you.
And it is, I think we discussed this, it's limited to the next quadrennial period, I think 2019 to 2023.
Yes.
And from 2023 onwards, it will all drop out because it's just spread over those 4 years.
From 2023, it drops out partly because a decision was made to incorporate the entirety of the McCloud costs within that valuation, and secondly because the 2020 valuations, as was discussed yesterday, don't include
Have been completed without McCloud costs.
Without any legacy scheme costs.
So we're certain there's no shadow, put it that way. Yeah.
Thank you.
Thank you very much. Mr. Giffen.
And I just start by saying that I think everything my friend Mr. Short has just said is, as a matter of fact, entirely accurate as I understand it, and I think in line with the understanding the Lord Justice Nugee had expressed. Now, exactly how one then wants to characterise it and say about its significance then is a different matter. I don't think there's any dispute between us about the actual factual position, therefore, so that's helpful.
I've got one little wrinkle, I'm afraid. But it may make no difference at the end of the day at all, but Mr. Short accepted that in some cases employers have borne some of the McCloud costs because the ceiling breaches have been waived. And indeed that is reflected in some of the evidence in the supplementary bundle. But I wonder whether that's entirely accurate, but it's only in those cases the employers have ended up picking up some of the McCloud costs. The effect of including the McCloud costs in the cost control mechanism is that the floor breaches don't take place. I think in any scheme, I think it's all the schemes that the floor breaches have been wiped out.
Correct, as I understand it, yes.
And in some schemes, there would have been ceiling breaches that they've been waived. But even in the schemes where there weren't ceiling breaches, what that doesn't necessarily mean the employees have picked up all the McCloud cost, because the McCloud cost is a figure. We have a figure, 4 billion a year or whatever it is. It's not obvious to me that all of that 4 billion a year would otherwise have gone in benefit improvements. That depends upon what the rectification would have been necessary if there had been floor breaches, which might be worth less than 4 billion. So it might be that even in a scheme where there wasn't a ceiling breach, the employees have missed out on improvements, but they haven't missed out to the tune of 4 billion a year. But
Lord is, with respect, absolutely right, because the
remedy of the floor breach would bring you back up to your target
figure. The target,
the 16.8, 16
set at the same as the cost cap rate.
Yes.
Indeed. So if hypothetically the floor breach was, shall we say, a 1% outside the margin, therefore a 3% deviation. If the McCloud costs
if they had an extra
amounted to 4%,
yes,
you'd only actually recover 3/4 of them.
And the rest was left to be borne through the employer contribution.
Indeed, absolutely. Well, yes, that's right.
So the answer is we don't actually know how much of the McCloud costs end up being borne by the members.
No, one doesn't know that, and one won't know it going forward, as my learned friend Mr. Short, again, right as I understand it, has said. The most recent valuation, the 2020 valuation, is different in certain respects, and that is a consequence of the review by the government actually, which is not directly relevant to this litigation, but one sees it as part of the thought process in the evidence. There were questions raised as to whether the CCM actually, as designed, sort of worked satisfactorily. So the government actually carried out the review, made 3 principal recommendations, and that's why the 2020 exercise is materially different.
Is Mr. Short factually right that it excludes any legacy scheme costs?
I believe he is. I would want just to check. I was correct on that. I believe he is. Yes.
Thank you.
Thank you. If you would check, that would be helpful.
Absolutely. And the other thing I should just perhaps say is possibly some of what fell from my Lord Justice Nugee might have suggested that on the waiver of ceiling breaches, it was sort of a kind of trade-off or quid pro quo. In policy decision-making terms, that's not in fact how it was looked at. It was, as I understand it, more an issue of concerns about whether the CCM is really working in an appropriate way. It doesn't alter the sort of bottom line impact or otherwise on members, but it's not decided upon as a sort of, we've taken away with one hand, so let's give a bit.
I see. Yes, thank you.
But we don't have any material about that. other than knowing that in some schemes there were scheme breaches which were waived. That's all we know.
I thought the ministerial submission perhaps was in the bundle.
Okay,
it
well,
certainly was below. I will check that as well.
over the short adjournment, would you check that for us? Thank you.
So,
I don't want to delay you anymore.
no. So, my ladies and lords, I'm going to pretty much take the 4 issues in the same order as the appellant. So, starting with the construction stroke Hadfield argument, I want to make 3 general submissions before looking in more detail at section 12 and for instance the Short's arguments. The first of the general submissions is this. It is right that there is no dispute between us here about the general state of the law. Of course it is the case that statutory discretionary powers have to be exercised for the purpose for which Parliament has conferred them, and that may be an implicit as well as an explicit purpose. It is, however, perhaps worth emphasising, as Spathome makes clear, identifying a Hadfield limitation on a statutory power is an exercise in statutory construction, and although, of course, one construes the statute in its context, the language used by Parliament is the primary consideration or the starting point. And if you have what are on their face general and unlimited words, you need some sufficient positive reason to imply into the statute the suggested limitation. And running from Mr. Short has already opened Spathome to you, so unless you would like me to turn it up, I will simply perhaps give you the particular page references. These are report page references, and that's Lord Bingham at 384D and 392G, Lord Nichols at 396F to G, 397B, 397H, 398C to D, and Lord Cook 402G, principal points. And that is perhaps especially true, I submit, whereas is the position here. This is not a case where there is any suggestion of the reasons for the exercise of the power or the nature of the exercise of the power having strayed into an area completely extraneous to the true statutory purpose. So the argument in Spathome, albeit unsuccessful, was that this is all about inflation control, and it was the power was being used to mitigate for tenants a change in the understood state of the law about how rent review clauses operated. Or, just to take another example, there has been a successful Hadfield challenge to guidance about pension scheme administration in the local government scheme, where the guidance was used in effect to bolster the government's foreign policy or prevent it from being undermined by it. So going, as it were, completely off piece. So we're not in that area here. Clearly, these directions were being used in broad terms for what the CCA is about. The second general submission I make, although it's the point which I apprehend from questions yesterday that the court has well on board, is that one cannot confuse the way in which a power has in fact been used as a matter of policy with a limit to the way in which it is lawful for the power to be exercised in the future. Of course, one can get legitimate expectation arguments arising from what's been said and done before. Those were run below, failed, and have not been revived. So we're down now purely to what the statute authorises. And similarly, I submit, the fact that Mr. Short can point to potential uses for the various powers in section 12 which are consistent with his construction, as certainly to some extent he can, does not, in my submission, either entail or indeed offer any positive support to an argument that that is the only way in which they can be used. And again, Lord Bingham in Spackholm at 385E to G, by reference to early authority, makes the point that a statutory power can have more than one purpose, can be directed against more than one mischief. And the third and last of my general submissions, looking at section 12 at a high level before we get into the nitty-gritty of it, there are in my submission two key things to say about the context in which it falls to be construed. One is that there is in my submission not the slightest doubt about the mischief which section 12, the CCM, cost control mechanism, was introduced to address. And that was to guard against public service pension costs becoming unaffordable or unsustainable, or an unfair burden being placed on the taxpayer, or an unfair share of the risks being placed on the taxpayer. And we haven't, I think, yet opened the Hutton report, which I think is common ground, is the sort of origin of the legislation. But perhaps one could go to many references in it. I will just pick out 5 brief ones, if I may. It's in the supplemental bundle. It starts at page 93. And at page 1, there are various preliminaries, introduction, an executive summary at the start, and including page 100, the deal, tabulation, and it's presented as a fair deal as between public service workers and taxpayers. And the third item in the taxpayer column is fixed cost. The government should establish a fixed cost for the employer's contribution to public service pension schemes. If cost grows beyond this level, action will be taken again back to this level. At page 107, which is the executive summary of the recommendations, the relevant recommendation is recommendation 12, and just above the pink box in which that appears, you see the sentence after they've referred to changes to certain design features helping to control the risks. They then say, however, an additional safety valve, cost ceiling based on proportion of their total pensionable pay bill, is needed in case costs within the new schemes increase due to factors not taken account of in the scheme design. This will ensure that public service pensions remain affordable and sustainable.
I'm so sorry, Mr. Gibbons, my fault. Which page is that on?
That is page 107, and it is the 4 lines or so immediately above the recommendation 12.
Thank you very much.
And then at page 114, chapter called The Deal, and there's a summary in the pink box, and the anti-penultimate bullet point: the taxpayer should have certainty that public service pension scheme costs are under control. The government should set out a fixed cost ceiling for each scheme, which is the proportion of pensionable pay public service employees will contribute on average to employees' pensions over the term. And then page 123, which is further on in the same chapter. And this is really the part that introduces the cost ceiling proposal. Paragraph 2.33, guaranteeing that public service pension schemes are designed to deliver at least adequate levels of income in time will help maintain the trust that scheme members have in schemes and minimise the need for means-tested benefits from public service pensioners. However, and this is the relevant sentence, taxpayers also need to be reassured about the future sustainability of the schemes. And finally, at page 125, I'm not going to read 125 to 131 in full, which is really the section that discusses how a ceiling might work, but paragraph 4.26 encapsulates the rationale for the proposal. However, the Commission believes consideration should also be given to an overriding mechanism to ensure that public service pensions remain affordable and sustainable. This mechanism would act as a safety valve in case costs within the new scheme increase due to factors not taken account of in the scheme design. And ladies and lords, it is right to note that what eventually went into the 2013 Act is not identical to the Hutton recommendation. In particular, the government was persuaded by the trade unions both to introduce a floor as well as a ceiling, and fatally perhaps to introduce transitional protection. But I suspect it's not in doubt, though not in dispute, that the essential rationale for the CCA remains as Hutton expressed it. You will, of course, note, though without going there, Mr. Elks refers at paragraph 34 of his statement on page 40 of the bundle to a white paper or similar called Good Pensions, which was the sort of intermediate step between Hutton report and bill, and that expresses the purpose very similarly. And one sees it again, I will just give the reference unless I'm asked, similar expression in the November 2012 cost cap paper that learned friend Ms. Morris showed you, which was put before Parliament when it was considering the bill, pages 138 and 140 in the supplementary fund, show you again similar high-level rationale. So that's one of the two sort of higher-level points. The other is this.
Just before you leave the Hutton report, did Lord Hutton's Commission express any views at all as to what costs should go into the cost control? The bits you showed us just say that employers' costs should be capped.
Lord, I think it's a fair. I will show you, Lordship, that. I think it is a fair summary. I hope it's a fair summary to say that he flagged up some of the issues and gave some hints as to thinking, but said it was ultimately a matter for government to decide as a matter of policy after discussion with stakeholders, including unions.
So we don't find in his report the discussion about what are member costs and what are employer costs or anything like that?
Not as such, and certainly not this is what they should be. But may I just give the Lord, I should say before Hutton even came along, there was something called a cap and share mechanism in some schemes which had some similar ideas and raised some similar issues. So it doesn't kind of emerge fully fledged from an egg, but it is. if my lord were to look at the foot of page 117 of the bundle,
Yes.
defining the risks, and that goes through to page 119. Really, it's the section through to 121. And it's talked about in terms of different kinds of risks. But if my lord was to look through that, you can see it has an affinity, if that's a fair way to put it, the sort of idea that some things should be member costs and some things should be employer costs. I'm looking for the bit where it says that should be thought about and discussed. Find it.
Yes, I see. Thank you.
Yes, I'm fairly sure he said somewhere it's a matter of a policy decision, but so the origins, it has its origins in the 17th, indeed prior to that in Catholic. Does that answer all the questions?
Yes, thank you very much.
So the other sort of high-level contextual point I wanted to make about section 12 was this, that even before the McCloud problem came along, there were always going to be new and legacy schemes existing in parallel and which were intertwined in various ways, some of them potentially quite complex. Past service in the legacy schemes, then the relevant members moving to the new scheme, transitional protection, as we've seen section 18 contemplated, applied to different people, potentially in different ways, e.g. the tapering, and indeed the potential need to use ongoing employer contributions to fund past service deficits in the legacy scheme. And what I submit against that context, Parliament has enacted in section 12, in that context of a broad cost control objective and a need to address a relatively complex relationship between new and legacy schemes, is a very general power to decide what costs to count and what legacy scheme costs to count. And I ask rhetorically, why would Parliament, as a matter of objective intention, be thought to have sought to constrain the discretion in advance? And especially, why should it have done so to limitations which, on the way my learned friend Mr. Short puts his case, turn on some really quite fine distinctions which, as he frankly acknowledges, are not easy always to apply. And what I say is that Mr. Short's case amounts to a very skillful attempt, but nonetheless an attempt to make an entire wall of bricks out of the odd wisp of straw to be found in the wording of section 12, subsection 1. But when you stand back and look at what section 12, the CCM, is all about, it just doesn't, in my submission, make any kind of sense. So, ladies and lords, I then turn to look at the detail of section 12, which, as you know, is in tab 3 of the legislation at page 17. Much of what we want to say is, of course, in the skeleton, especially paragraphs 25 to 40, which I will ask the court to reread at some appropriate moment. But I will take it orally under 4 headings. I'll just identify what they are. First, the words, quote, used for the purpose of, close quotes, in section 12, sub 1. Secondly, the various references to connected schemes. Thirdly, the idea that my friend's suggestion that this is about changes to the cost of an already identified package of benefits rather than change to the package itself. And as part of that, I address the significance of section 22 of the Act. And then fourthly and finally, the discrete point about whether McCloud remedy costs fell outside section 12 because they were the costs of putting right a legal wrong, and that is a different excluded category. So, first heading, the used for the purpose of in section 12.1. As you know, so scheme regulations must set a rate expressed as a percentage of pensionable earnings to be used for the purpose of measuring changes in the cost of the scheme. Now, it's obviously right to acknowledge at the start that the scheme, in the closing words, is the new scheme because it's a scheme under section 1. Section 1 establishes the new schemes. But that acknowledgement, however, comes with 3 related buts attached to it. The first but, which is really the point in paragraph 35 of our skeleton, is that measuring changes in the cost of the scheme is not here expressed to be the purpose of the cost control mechanism, nor is it expressed to be the purpose of section 12. That is not what it says. It is simply said to be the purpose of the percentage rate. And that indeed is exactly how it works under section 12, subsection 5, which is in fact the real substantive part of this CCM. I say it's section 12.5, more accurate to say it is the scheme regulations which section 12.5 requires to be made, but section 12.5 shorthand is the substantive CCM provision. And that's right, it's measuring changes in the cost of the scheme as per the percentage rate, because it is when that percentage rate changes, or changes sufficiently, that alterations to benefits or contributions are triggered under section 12, subsection 6. So, that is accurately described as the purpose for which the percentage rate is used. But when section 12.4c talks about the extent to which costs or changes in costs are to be taken into account for the purposes of this section, that is something wider. That is the purposes of section 12, and therefore the CCM more generally, and it includes that purpose one identifies in the general context which I described. That's the first part. The second part, and it's a closely related one, is that substantively, this is the point in paragraph 34 of the skeleton, all that section 12 subsection 1 is actually saying is that the scheme rule regulations have to include a specific percentage. It's the 16.8 in the fire regs and the 11.6% in the NHS regs. It's a bit of mechanics, section 12. So the idea, which is at the heart of, and indeed in some ways is the entirety of Mr. Short's case, that this mechanical provision actually operates as a vital substantive constraint on in my submission, a far-fetched. That takes me to my second head of submissions, which is also the third but, and which qualifies the fact that cost of the scheme at the end of 12.1 is the new scheme. And the point here is that one cannot read section 12 sub 1 in isolation when it comes to identifying the proper purpose of the section 12.3 power, which is power actually concerned with. You have to read section 12 as a whole, of course. And the reference in section 12, the undoubted reference in section 12.1 to new schemes, has to be read in particular with section 12.4c, which shows, says in terms, that it is open to the Treasury to count in the costs or particular costs of the legacy schemes. And that is expressed to be and is a general discretion, which makes eminent sense in the light of the point I've made about the complex ongoing relationship between new and legacy schemes. And once it is acknowledged, as learned friend Mr. Short has to do, and frankly does, that legacy scheme costs can be included, there is in our submission no satisfactory or sensible line that can be drawn, still less one which the legislative wording compels to be drawn, between those legacy scheme costs which can and those which cannot be counted. Now, my Lord Justice Nugee, in the course of my learned friend's submissions, asked, I think, how do you identify the costs that cannot be counted? And with respect, I'm not sure Mr. Short really answered that question. His response was to say that the choice that faced the court was either to be consistent with subsection 1, or to extend it. But not only does that not, with respect, answer the question, it is in any event a false choice. Section 12.4c indisputably amounts to an extension of section 12.1 in the sense that 12.1 only refers to new schemes, and the whole point of 12.4c, manifestly, is to bring in legacy schemes as well. And there is no inconsistency between the two, both because you read the section as a whole, and because of the points I've already made, my first two blocks, about what it is that section 12.1 actually says and does. Now, I know from Mr. Short's only other attempt, I think, to address this crucial question of where must you draw a line, was to try to show that the uses in fact made of legacy scheme costs in the original directions of the counting in of such costs concerned costs that in fact had some relationship with the new schemes. But, I've already made the point, what was in fact done does not drive or define what can be done. For what it's worth, the submission I've just made is my primary submission, but it was sent to draw a line there. But for what it's worth, the November 2012 documents, which were produced as part of the bill process, clearly show that this was always regarded, and in my submission, rightly regarded, as a policy choice. And I can make that good, first of all, by reference to the document at page 136 of the supplementary bundle. Sorry, that is 134 is the starting page. or even 132, it varies by 132 is the rule. We've seen the document already, and page 142, under the heading costs that will be controlled by the CAP, it identifies the various different elements of scheme costs that the employer's contribution rate has to cover. This is 1.14. So past service, future service, new and legacy schemes, different terminology used, and active deferred pension members. And it explains those concepts a bit. And then at 1.18, it says employers will pay a contribution rate which reflects all of these elements of the costs of the scheme. However, the cap mechanism will be designed so that some of these elements are excluded. As only active members will see their benefits or contributions adjusted if the seal of performance breached, the government considers it will be unfair to control all of the costs associated with pension and deferred members of the existing pension schemes. I emphasise the word all, because some of them were to be controlled. So these elements will therefore not be controlled by the cost cap mechanism. Cost cap will control all other member cost risks, and it sets them out, and that then takes us into the discussion about what are member costs. The point here is the bill was presented, and in my submission, nicely presented to Parliament as one under which there was a policy choice to be made about what went in. The attack on the policy choice, subject to the Mr. Short's discrimination argument, has been attempted and has failed. It is not, in my submission, well founded as an attack mounted as a matter of construction. If the court would wish to have the references, again, I won't turn it up, but in the later November 2014 document, which is...
Just before you go there, can I ask you two short questions about this November 2012 document? I think you told us this was produced alongside the bill for members of Parliament, is that right? I will
give your Lordship the precisely right answer, which is in Mr. Elk's statement, which starts at page 28 of the supplemental bundle, and it is page 43 of the bundle. And it's also paragraph 43 of the statement.
Yes, assist scrutiny at committee stage.
Indeed.
So, was it public? Was it I don't know how these things work. Was it a public document, or was it just given to members of the committee, or was it available to all members of Parliament? What was it? How does it?
Someone for another party or on my own camp will correct me if I'm wrong, but my recollection is that these were published, perhaps on a website, and I think that must be right, because they were, I think, produced by the claimants as a part of their challenge. That was it. And I don't think they've got them on disclosure. So I think these were made publicly available. But I hope someone will correct me if I have that wrong.
Thank you. The other question I had...
I'm told I'm right.
On page 142.
142.
142. Paragraph 119. This draws a distinction between, well, 118 and 119 together, draws a distinction between deferred and pensioner costs in the legacy schemes and costs of active members, including legacy scheme members. And it seems that the third bullet to include all cost risks associated with transitionally protected active members. And I think the position is that wasn't what in the event happened?
Well, it's inevitably perhaps a little more complicated than that.
Mr. Short showed us in the directions that transitionally protected members, for the first set of directions, were treated as if they didn't have transitional protection for the purpose of the future service accrual over the 4-year period.
And that is right. It's not the whole story, however, because, and that's how the initial, whatever it's called, the preliminary evaluation works.
Yes.
However, it's not the case, it's not accurate to speak in terms of those costs being excluded, because when it comes to subsequent valuations, any change in the costs of the transitional protection will be taken into account, and that is direction 41, if I have it right, which is we are in tab 10 of the legislation.
If it's more convenient to do this later, I don't want to take you out of your course, but in November 2012, it doesn't seem that these subtle distinctions between which bits of a transitionally protected member's rights are being brought in and which aren't had already been drawn. Is that right?
Certainly they were not fully developed, because the sequence is November 2012 is a bill committee stage, broadly speaking. You then get royal assent at some point in 2013. D-Day, as it were, is 1st April 2015, in the sense that that's closure date of the old schemes and the new schemes starting. We're then also sort of starting to think about the 2012 valuations perhaps are done in the course of 2015. I forget the evidence on that 14-15. So it's at that point that the more detailed and sophisticated Treasury policy paper from November 2014 is published, explaining, in effect, the thinking for the directions. Then, of course, the directions themselves are made on some date in 2014. I'm guessing there's actually and then March 2014. Okay, so actually the paper comes a bit after the directions, so they must have been seeking to explain it at the point at which it would start to be of practical importance. But November 2014, that's the paper at page 164, you then get a more developed or sophisticated set of thinking. And what is said in there about transitional protection, this will probably just about take us up to the shorter journey. Helpful.
164. We're at 164. Yep.
Is where the document starts, and I am riffling for the bit. Okay. Yes. Page 179. Paragraph 2.19. Firstly, the government's, having described the basic approach, paragraph 2.18 says there are going to be 3 adjustments. First one, 2.19, government's commitment to provide transitional protection to those closest to retirement means that there will be members of the existing schemes who will continue to accrue benefits in those schemes after close. The contribution rate as calculated by the preliminary valuations will reflect the costs of providing these benefits. That's the first purpose of valuation. However, these are likely to be different costs of providing benefits under the new schemes in isolation, meaning that the overall employer contribution rate will change as protected members gradually retire or leave the existing schemes. The cost cap will therefore be set assuming that no members are entitled to this protection to ensure that the level of the cap is not distorted by this transitional effect. And that's the point, in effect, my Lord was discussing with my learned friend, was Morris, at some point where she was showing the whatever ministerial assumption referred to an assumption that had been shown to be wrong by McCloud. And then
But this reference to a cost cap is to the original. Is that the original setting of the rate, the 16.8% figure? Is that right?
Correct.
And that figure doesn't change from year to year. It's set in the regulations, and each quadrennial valuation you measure whether you've deviated by the margin from that figure, but the figure itself doesn't change.
The figure itself doesn't change. I mean, the point is that you, if I've got this right, again, someone correct me over lunch, I got it wrong. When your target figure, your
benchmark
figure stays the same. When you are calculating the costs for the purpose of setting that in 2012, you just assume no transitional protection.
Because you're setting it for the entire future period. This is on the assumption that the 2015 schemes will be set for 40 years, 25 years.
That would otherwise be a distortion.
Yes, I see.
And you're assuming that this category of people is going to dwindle pretty rapidly.
Yes, as indeed it would have done had it not been for the cloud.
Yes.
Yeah.
But when you then come to look at how your actual costs have
Whether they've deviated from the target.
you do look at the actual costs, which includes the transitional protection costs. I'm sorry, that's not the that's an inaccurate. Includes costs actually incurred in or expected to be incurred in providing benefits which are transitionally protected benefits.
It includes legacy costs for active members. Is that?
It does.
But not legacy costs for deferred and pensioner members.
Correct. And some of those active members will be active members who, through transitional protection, are in the legacy scheme. And I hope that's what Direction 41, part of what Direction 41 is. Can I just, before we break, just without reading it, page 186 is, one of my friends, Shaw, was seeking to answer my Lord's question yesterday about how you would say, well, how in an unfunded scheme, how do you quantify past service costs in effect? So page, what Mr. Short said was right, I think, and page 186 about the state approach explains that a bit more. And then finally, there is somewhere in the annex. It is. I think pages 196 to 197 under the heading Operation of the Employer Cost Cap completes the picture. But ladies and lords, that would be a convenient moment. Someone will be able to tell me over the journal why everything I've just said is completely
I do hope not, for many reasons. But also, if you, I'm sure, are going to go on at 2 o'clock to clarify that point about transitional protection and where the line comes in relation to those who will be, the transitional costs which will be taken into account, and those that won't, between because it's not a clear line between actives and deferreds and pensioners. And I think you're going to do that by taking us to 41, which then takes you back to 37 and 39, I think. But I'd be really grateful if you could flash that out at 2 o'clock. Thank you very much.
All right.